receive a subpoena or summons, it's most likely that you will have previously prepared a statement for the police in your involvement and care in the treatment of a patient. As a general rule, if you are served with a subpoena or a summons, you must comply with it, unless, of course, the order is not validly served or is otherwise invalid. It is important to understand the capacity in which you're being called to give evidence. As the treating doctor, you're being called as a witness of fact. This means that you're being called to give factual information, that is, simply your involvement in the treatment of that patient. It is important, therefore, that you are clear what your exact role in the treatment of the patient was. Did you carry out the assessment of the patient, or was it your responsibility to take the notes? This will help in framing your evidence and ensure that your evidence is factual and consistent with the clinical records. Going to court and giving evidence can be quite a daunting and stressful experience, but there are a few simple things that you can do to make it easier. Dress appropriately. I recommend business attire. Remember, you are a professional. Look like one. Ensure that you arrive at the court early, giving yourself plenty of time before the hearing. In addition to travelling time, you should also allow sufficient time to get through any security checkpoints, which may be set up at the court. Know which courtroom you need to be in and how to get there. If you can, try and have a look at the courtroom so that you can see the physical layout. Know who you have to meet at the court. This will usually be the person who has issued the subpoena or summons. It is possible that the person who has called you will want to confer with you before giving your evidence. If no arrangements have been made, go to the court office or inquiry counter and ask where you should wait. Take time to review the statement you previously made before going to court. Confirm if you will have access to your statement and clinical records while in the witness box, or whether you will need to bring your own copy with you. You will be called into the courtroom when it's your turn to give evidence. As you enter and leave the court, if the judge is sitting, you should bow your head to the judge. The court officer will show you to the witness box. The court officer will read out the oath and ask you to swear to tell the truth on the Bible or Quran. Alternatively, you can simply give an affirmation to tell the truth. You will be asked to state your full name, your professional address, then your professional qualifications. The Crown Prosecutor or legal representatives for any represented parties may ask you questions. Similarly, the judge or magistrate may ask you questions. When answering questions, respond to the person who's asked you the question. When you give evidence, it is important that you speak clearly. You should avoid using profanities, slang, or acronyms. If you use medical terms, you should explain them in terms that the court will understand. If you do not understand a question that has been put to you, ask for it to be repeated or rephrased. Only answer the questions that you are asked. Avoid trying to fill any silences. If you do not know the answer to a question, then you should say, "I do not know," rather than trying to say something that you're uncertain about. In the same vein, if you're unable to remember a particular issue, then it is perfectly acceptable to say, "I cannot recall," or "I do not remember." Remember, the evidence you give should remain within the scope of your expertise. It is important that as a junior doctor, you do not stray into providing expert opinion. For many doctors, giving evidence will be an infrequent event during their clinical career. Contact Avance Medico-Legal Advisory Service beforehand to discuss the matter, and we can talk you through the process of giving evidence and any technical legal issues for your jurisdiction. You can call us on 1800 128 268.